terrible turnout in Outagamie and Brown counties. They had a huge turnout in the city of Madison. You know that's not going to end well. I can think, yes.
Are you going to defend Tony Evers in that lawsuit? What is it? I forgot what the background of that.
The background is there was a court case in the Supreme Court 2 or 3 years ago in which the court concluded because Evers is an independently elected constitutional officer, the legislature couldn't have a certain control over him on an issue that dealt with promulgating rules within his department. They had given authority to the governor to be able to have some oversight over that. The court, we think in a terrible decision, concluded that that independent constitutional officer was kind of above legislative control. That, I don't believe that's accurate. I'm an independent constitutional officer. I don't believe I'm above legislative control. Well, after that court decision, the legislature passed a law to try to address that court decision. And now, Superintendent of Public Instruction said that doesn't apply to me. So the Wisconsin Institute for Law and Liberty filed a lawsuit to say it does apply to you. They're looking for a declaratory judgment from the court saying it does apply. Well, there are times when I represent a state official in their official capacity. There are times when I defend the law. In this particular case, since the Superintendent of Public Instruction says the law doesn't apply to me, I've got to make a choice between representing the public official or defending the law. Ultimately, I don't think there's any other option, but in a rule of law nation, I don't defend the person, I defend the law. So at DOJ, we took the position that the law does apply, we'll defend it. And we also took the position that for the Superintendent of Public Instruction, we represent his agency officially. And we disagree with him on the law. So he filed a lawsuit challenging that he should be able to represent himself. We took the position, you may get outside counsel to represent your position. The court should hear this position throughout the arguments, but ultimately we're defending the law, and we are the state, because I am ultimately the state's lawyer. So that's what the Supreme Court just heard arguments on, was just that side issue. We're not getting yet to the issue of whether the law actually does apply to the Superintendent of Public Instruction. Right now, all we've argued so far is whether he gets to get his own attorney and then he gets to be the state in the argument versus DOJ being the state in it. I thought the questions from the justices were interesting. I'm not going to try to read the tea leaves here because we tried to do that a couple years ago in that other decision that we thought we had and didn't win, so we'll see. Yes?
Just a general question. Do you think that the legislature is kind of overwhelmed and the issues there's so many issues and some are trivial, some are not, and some are very complex, some are not, and like you say, some of them are probably farmers, and do you think we're overburdening the legislature or no?
Well, you'd probably be better to ask a legislator that, but well, I don't think so, because there are 99 individuals. And part of the reason why there are so many issues in front of them is because there are 99, and most of them are working to submit bills to try to get issues that are important to their constituents heard. So it does build a lot, but I've generally found that legislators, they need a little time to get up to speed because a lot of these things will be outside their realm of expertise, outside the legislature, but get them up to speed. And that's really, one of the roles we play. I have a government affairs person at my office that's what she does. She goes over and makes sure if there's a bill that's important to us, that we're making sure the legislators on that subcommittee are gonna know what the issues are and what the highs and lows, the good and bad is and everything. I don't know, but I don't know what the I mean, if they are overwhelmed, the only solution would be try to pass less stuff, and that's generally good. I mean, legislatures were supposed to be designed in the founding fathers' intention to not do an awful lot, that don't be changing things constantly, but maybe have some consistency in.
Back in the early century, we didn't have as many issues, I don't think, as we have now, and like you said, there's 99, but it gets so complex, like, you want, what is it, the big thing that's going on now? How do you, yeah, I know, maybe I'm, like you said, I'm asking the wrong person, but to me, it's overwhelming.
When I started in the DA's office, in 1989, the state statutes were 4 volumes, and I would say overall, stack them all together, is about this wide. There are now 6 volumes of the state statutes, and I'd say overall, they're about this wide. We've added a lot more laws. Sometimes that's good, sometimes not so good. Yes?
I hope I can explain this correctly. This past winter, a group of friends and I went to Madison and we talked to our legislators. Wisconsin has an anti-abortion statute on the books. It's been somewhat weakened in the last decade. But we talked to them about just complete abolition of abortion. And they said, several of them said, you need to go to Brad Schimmel, you need to go to the Attorney General. He's the one that would enforce it. So are you willing to?
I am a pro-life person from womb to tomb, and I make no apologies for that. Both of my daughters are adopted, and both of the 18-year-old young women who gave us the chance to have a family are remarkable young heroes and demonstrated great courage in what they did. But that aside, the statute, our anti-abortion statute, is not enforceable because of court decisions. It is null and void, but we've left it on the books. Because to take it out of the statutes, even though a court has made it unenforceable, we have the same thing with adultery. The adultery statute is still on the books. It is a crime in Wisconsin to commit adultery, but it's not enforceable because a court has said it's not, because it's unconstitutional. Therefore, in order to get a statute removed from the statutes, the court can't do that. They can say, we find it unconstitutional, and we're not going to permit you to enforce that. But they can't erase it from the statutes. Only the legislature can do that. Nobody's taken it up to pass a bill to remove it, and I know that the Right to Life groups in Wisconsin have supported that, because if we're ever able to get the U.S. Supreme Court to modify or repeal their decision or overturn their decision in Roe v. Wade, if they ever did that, Wisconsin then still has an abortion statute, and we could.
Sure.
If we remove it though, and Roe v. Wade gets undone, we'd have to come back and have a legislative debate as to whether we recreate an abortion prohibition.
Sure, I get that. What about the 10th Amendment, though, that states' rights?
Yeah, ask
Or
them.
the federal government, states are supposed to be autonomous.
Oh, I know.
It's courage to do that.
I know. The Supreme Court in Roe v. Wade and in many other decisions since has created constitutional rights out of thin air. And it was certainly argued that the 10th Amendment should leave these kind of decisions to the states. And the court rejected that, because they found that to be a constitutional right to privacy buried in a whole string of constitutional provisions.